Good morning, my name's Alex Woods. I'm a financial mis-selling solicitor, and this is part 7 of the 10-part series in which I try and add a practical insight to the guidance note and to flesh the contents of the guidance note out for the benefit of insolvency practitioners. And today's question is, what about closed IVAs? What about closed IVAs? And I think they are quite a different category of insolvency, of financial selling and insolvency, and there are different sets of rules that apply. Now, I'm going to touch on the guidance note and extrapolate and explicate what the guidance note says about the issue, before then going on to the law, referring to a case where I consulted counsel on this very issue, and then I'm going to give you some practical examples from day-to-day business before wrapping up and concluding. All right, now, I think probably the first thing to say, and if you are busy and you want to go no further than this introduction, then in the main, my view is that unlike open IVAs, where the costs do require that you at least do an audit into the issue, as far as closed IVAs are concerned, I'm not convinced that the insolvency practitioner should feel themselves under a duty or an obligation or a burden to address the problems of an ex-debtor client bringing their own payment protection insurance claim or bringing a payment protection insurance claim with the claims management company. The IP then finds that the bank then contacts them because it doesn't know what to do with the refund. In those situations, I think it's fair enough if the insolvency practitioner says, I don't feel obliged to act as trustee post completion and to gather up the assets and reconvene and distribute the proceeds of the PPI refund post completion as a post IVA dividend to the creditors. So I just simply, generally going forward, that's my view. There are exceptions, and if you want to hear about the exceptions, I will come on to them. The first thing to say is about the guidance note is that don't forget that the guidance note is quite clear in. Let's have a look at the relevant sections. Sections 14 refers to section 14.1 of the R3 protocol, R3 standard terms and conditions, and section 10.6 of the protocol standard terms and conditions. And the guidance note really explains that you shouldn't feel obliged to have to keep open an IVA. It's keen to stress the point that IVAs should not be kept open in order for any lengthy period of time in order to realise PPI assets. And whilst it says obviously you should refer to your individual terms and conditions, if you look at the R3 or the protocol terms and conditions, they both say the same thing. They both talk about once the formalities of the IVA are completed or concluded, the IP is still empowered to deal with any other matters that may have arisen during the course of the IVA. So if it's become obvious that there's a lot of payment protection insurance in your IVA, complete and then deal with it post-completion. Unless there's some exceptional term in your own individual IVA, I think that the caveats, those clauses in the protocol and the R3 terms and conditions, fully allow you to do that. So you shouldn't be afraid about keeping the IVA open in order to realise PPI assets, which is what a insolvency practitioner whom I first dealt with when I was running an IVA insolvency PPI processing unit at my first law firm was concerned. It was keeping the IVA open, but I don't think that's required. Now that's a particular category of closed IVAs, if you like. What about where the IVA, we've got a PPI claim which is brought by a debtor client and you're simply asked, perhaps by the client, unlikely, but the bank comes to you and says, what do I do with the money? I don't think really there are any other permutations. I know that some insolvency petitioners, at least I've discovered one insolvency petitioner who has set up a claims management company arm, which is then proactively contacting clients and slightly disingenuously, to be fair, saying, look, we can realise your PPI refund, and not quite explaining to the debtor client that the realisations will be taken by the insolvency practitioner themselves. But on the whole, I think the only way that you're going to come up against this issue is if a bank basically contacts you with a PPI refund and wants to know what to do with it, and then you're thinking, well, what do I do? Now, I would say the guidance note, first thing to notice, the guidance note states that you are under no obligation or duty to act on that. You may have a power, depending on the terms of your IVA proposal. You may be a trustee. The asset may vested in you as a trustee post-completion. So that's first to say. Now, I'm going to go on to what the legal position is pretty unclear about whether a insolvency petitioner is a trustee post-completion. And I had a case in which I instructed counsel at South Square Chambers, and we went through all the various different issues in relation to the PPI claim, whether it was captured or not, whether it was an asset, etc., etc., etc. The conclusion was that under the 2008 terms and conditions, the PPI refund could be under the 2004 terms and conditions, the PPI claim was automatically self-executing at the beginning of the IVA, was part of the IVA, and even though even post-completion, a bank was entitled to set off. This was an issue of set off, and we took the matter no further. The 2004 terms and conditions are more analogous to bankruptcy, and where that applies, set off is automatic and self-executing at the time that the IVA is set up at law, and even post-completion, it is deemed in law to have happened. So therefore, the bank, the creditor, is entitled to set off the PPI refund against its original debt. And indeed, in this case, the Royal Bank of Scotland had kept the account open. So I think that there you are. The conclusion was that there wasn't entitlement to set off. But if the PPI had been in a 2008 terms and conditions, then providing that the creditor had not exercised section 17(6) set off whilst the IVA, providing the issue had not been dealt with or addressed during the course of the IVA, post-completion, because 2008 terms and conditions set off are completely different from the 2004 terms and conditions, post-completion, the PPI asset could not be set off. The question that counsel then went on to draw a big question mark over was whether or not the insolvency petitioner, in where the asset vested, in whose hands the asset vested, and was it in the hands of the insolvency petitioner or was it in the debtor client? And he drew a big question mark over that issue. That was, a subject for a completely different advice. So I think that the area is grey, whether you're looking at the guidance note or whether you're looking at the law. And don't, blow a gasket or shell out loads of money on counsel's advice because they're going to give you that sort of a question mark response, in my view. You're not going to get a clear answer on this issue. You're going to have to use your noodle. So we come on to the examples, and surprise, surprise, the big watchword for me is one has simply to take an equitable view, and therefore you do have to do the spade work of looking at the individual circumstances of this particular client, and to a certain extent, setting aside the technical detail of the law, the guidance note, and I'm going to ignore that, the law, the guidance note, and and potentially your individual IVA proposal if it's not clear on the issue. So now here's an example. Got a client at the moment. The 2008, the IVA was completed quite quickly. In fact, they were obviously very unhappy about having this problem of being in financial difficulties as a husband and wife. The wife got into difficulty, the husband helped to bail her out basically, and within a year, 18 months, they'd actually concluded the IVA by payments of a lump sum, and they hadn't, and there was also a provision in the IVA relating to remortgaging the property. Anyway, the debtors had behaved in exemplary fashion. It was a post-2008 IVA. The creditors were happy. The insolvency petitioner was happy. The issue then arises 4 years down the track. They approach us. In fact, this case came to us through someone out there who basically offers advice to people on their debts, and he uses us where people have got they're in a post-completion situation, and they're wanting advice on what to do about a potential PPI claim that they've just discovered. And in that case, it's pretty clear. I have actually referred to the insolvency petitioner in question as a courtesy, really. It's not worth their effort to trawl through the IVA proposal, to resurrect the IVA, it's just, even if it were equitable, which it ain't, it's just not. The costs are going to exceed the potential benefits, particularly in these constrained times, insofar as capacity for insolvency petitioners to actually make any money at all, or at least make a living out of running IVAs is concerned. So, of course, insolvency petitioners aren't entitled to take referral fees either. So I did have put more flesh on the bones of these practical examples. With the first law firm that I set up a unit with, we did have a reasonably large, hundreds rather than thousands, but a few hundred IVA insolvency petitioner clients, and there were a number of closed cases. And really, they were sort of somewhat problematic insofar as one felt that one simply had to say to the insolvency petitioner, by all means write to these clients and explain that we can help to realise payment protection insurance claims for them, we can help them run their claims, but in terms of you being remunerated for it, there's not much that can be done. And as far as the duty and obligations that you have towards these closed IVAs, there's not much that can be done. Unless, as I say, it falls into that initial category where the matter has arisen during the course of the IVA and completion has occurred, and as far as the insolvency petitioner is concerned, he is simply dealing with formalities post-completion. But 2013, 4 years after, in the example I've just given, that caveat wouldn't apply. Now, but here's a somewhat different example. This was an IVA where there was it was quite a specific IVA in terms of what was included and what was excluded, and it was an IVA. It was a business that had run into difficulties, and the business was owed money by debtors, and there was legal action required in order to bring that particular debtor to heel. And part of the IVA included provision that once that money had been realised, then it would be paid to the IVA, etc., etc. In fact, it was a two-track IVA which said, 10p in the pound or 40p in the pound, depending upon the successful resolution of these legal proceedings. It was that kind of quite a specific IVA, and there was a lot of payment protection insurance, and it was rather tangled up with the business as well, and the clients were aware of the payment protection insurance claims, and it wasn't an issue in this particular case, but I'm using it as an example, a hypothetical example based on a real example. What might well have been the situation here is the matter might have completed, the legal proceedings might not have generated the envisaged assets, the creditors might have only got 10 pence in the pound, the debtor client is aware of a large quantity of money sloshing around, payment protection insurance, across their debts, and waits until, and perhaps also doesn't disclose fully the existence of those payment protection insurance claims, or the complexion of them, the value of them, to the insolvency petitioner, and waits and then makes claims, a bunch of claims, after completion of the IVA, a goodly time after completion of the IVA. Now you can begin to see where, one has to take an equitable view of these matters. There, it is well worth the insolvency petitioner looking into the terms of the individual proposal, and then I think quite rightly, not even necessarily needing to totally nail this issue of whether they are trustees post completion, because I don't think you ever will, and simply to say, and be a stand-up IP in this respect. No, I'm taking an equitable view of this individual voluntary arrangement. You, Mr. Debtor Client, shall make those paid PPI proceeds available for the benefit of creditors post-completion. So, as I say, I alluded, come on to just one further matter. Oh, by the way, I should say that in practice we find that when they are bashed a bit, I'm talking about co-op, for example, we've got a closed IVA. Generally, where the debtors have behaved themselves and the PPI has only reared its ugly head long after completion, it's a relatively, no, it's not relatively straightforward, but about 50% of those cases we argue with the banks in question. As I say, the co-op is an example that springs to mind, and if you argue your point forcefully, they tend to capitulate. Now, to come on to the IP who set up a claims management company that I referred to earlier, I don't feel I quite did that point justice. I've discovered through one of these debtor clients who came to us post-completion about their IVA, about a PPI claim, I discovered that there is a company, the name of the company is on the tip of my lips, but I don't want to unfairly muddy their name, because one wants to give them the opportunity to explain themselves. It's not my business. But there is a website out there, a particular insolvency petitioner, and they've clearly set up a claims management company alongside themselves as an insolvency practitioner, give themselves a different name, and in respect of both open and closed IVAs have put up information on the website which says that the money will be used to potentially reduce the term of your IVA, oil the wheels of your IVA, and that's the only benefit to the debtor client. So if you go onto the website to test the client, you'll discover that. They then got call centre nymphets phoning up these debtor clients and saying, would you like to make a PPI claim? And it's a little bit disingenuous. I mean, if you look at the website and you see that actually, no, I'm not going to get any of this money, and they say, we will charge 30%. It's disingenuous. The impression it leaves the debtor client with is, you'll get the money, we'll take 30%. If you look at the small print on a website, you'll see that actually it's meant to go into the IVA. Now, in an open IVA, and it's unclear, this website, as was the particular telephone nymphette who was questioned quite closely by the debtor client, who then sent me an email about the whole matter. it was unclear what differences might apply across open or closed PPI claims, and she kind of fudged it and gave him the same answer, and was pushing him to refer him to their claims management unit in order that they could follow up the claim. And I dare say that they're just going across all of their clients post IVA and trying to get them to sign up and then taking their 30%. I'm not sure how legal that whole operation is. So to conclude, I think that in the main, where it's properly well enclosed and there's water under the bridge, then I think you just don't go there as an insolvency petitioner. You've got a business to run. There's not enough money in it. You can't take referral fees. Let it go. However, there will be the exceptions, the caveat where you are completing early. The matter has arisen is the clue here. You're aware of a PPI claim, you're completing in order to deal with it afterwards, or where there's clearly been something going on, such as perhaps the debtor client has known all about a potentially large PPI asset, and really, in truth, they should make full and frank disclosure of that potential asset during the term of the IVA, or the time the IVA was set up, or even, at a later time, once they've discovered their existence and they've learned about the whole PPI scandal. I think that therefore there are exceptions, and it may be a large amount of money, and particularly if there have been any problems in terms of complying or delivering the promised pennies in the pounds to the creditors. There is always there always could be a good reason for you to put your, trusty post-completion hat on and get in there and realise PPI or any other financial mis-selling asset. Okay, thank you. Well, that's all for today. The next posting, part 8 of Actual Practice Post Guidance, will deal with the issue of whether the debtor should get anything out of it, ? And I think this is quite an interesting question, particularly if you're requiring the debtor to do any amount of work, and particularly because, don't forget, there is a certain amount of discomfort and ill ease about the whole issue of to what extent there were mutual dealings at the time an IVA was set up, where a creditor has previously unlawfully sold a payment protection insurance product. So should the debtor get anything out of it? That's Actual Practice Post Guidance, Part 8.